Well, we're delighted to welcome Jay Bender. He's the judge for the County Court at Law number 6.
Very good.
And he's highly respected in Collin County as well as our community, and he's our friend in Allen area Patriots. He's married to Lynn right here, has 2 beautiful children, and we're just so happy he's here to give us his knowledge. Thank you.
Thank you, Tracy. Thank all of you for having me here this evening. I'm sure it's just coincidence that Steve was talking about microencephaly. Just had nothing to do with me being here. I'm sure it's just pure coincidence. But I appreciate you having me. Before I get started on my speech about Supreme Court, you mentioned about the New York bill. You know, as Texas goes, we lead the nation. So what you should be aware of with regards to abortion is that in 2015, Texas passed a law that we were no longer going to support our state Medicaid dollars and pay them to Planned Parenthood because of what they were doing. And they got sued, Planned Parenthood sued. And you should be aware that the Fifth Circuit Court, which is our appellate court for the federal system here in the state of Texas, even though it's based in New Orleans, just yesterday, the day before, actually held that the state of Texas has an absolute right to not have to pay Planned Parenthood because of what they're doing to those unborn children. And not only that, you probably will recall in the media, it's just a couple years ago, 2015, I lose track of time, 4 years ago now. But you recall in the media how there was an undercover video that showed them what they were doing to those children. And the Fifth Circuit Court of Appeals actually held that not only was that video not tampered with, it was in fact factual and what gave rise to allow the state of Texas to withhold that funds. So just be aware, while New York has done these things just recently, there will be challenges to them. Other courts will be able to decide what to do with them. But just so you know, don't give up hope, because as they say, so goes Texas, so goes the nation. So just wanted to throw that out there, even though it has nothing to do with my speech tonight, because tonight I'm speaking about the United States Court. So if you fall asleep, I will understand. So the Supreme Court of the United States. That's a picture of the current, well, I say current makeup on the court. I guess there's some discussion about whether or not Justice Ginsburg is going to return or not. I don't know. But that's the current makeup of the court. And I know my son was kind of hoping that my picture would be on there. In fact, he wrote a letter to President Trump back when President Trump probably wisely chose Justice Kavanaugh for that position. But I will also tell you, though, I too like beer. Right? So here's the current makeup. So you have the Chief Justice, Justice Roberts. I'll come over here. I had taken some notes I didn't put on there. How does the Supreme Court work? The term, the annual term, actually begins the first Monday of every October. And it ends either at the end of June or the beginning of July. It kind of just depends on what the workload is of the Supreme Court. The current makeup is of the Chief Justice. Now, he was nominated by George W. Bush, number 43. Then Clarence Thomas, who was also nominated by George H.W. Bush, his father. Ruth Bader Ginsburg, who was placed onto the court by President Bill Clinton. Stephen Breyer, who was placed on the court by President Bill Clinton. Samuel Alito, who was placed onto the court by George W. Bush. Sonia Sotomayor, who was placed onto the court by Barack Obama, along with Elena Kagan. And then we have Neil Gorsuch and Brett Kavanaugh, who were appointed on the court by by President Trump. Now, you see that they're listed in order of calendar when they were appointed to the court, with one exception, and that being the Chief Justice. So how does one become the Chief Justice? It is merely luck. When the previous Chief Justice decided to retire, that position was open, and it ended up being John Roberts, who was nominated and subsequently ratified to that position. It's simply because that position was the one that was up. So it has nothing to do with the composite of the court. They don't vote. It's not the president. It's just whenever the Chief Justice's term, when Justice Roberts either passes away because it's a life term or decides to retire, then whomever is nominated to replace him will become the Chief Justice at that point. Okay, so I just wanted you to understand, while there is a Chief Justice, it's not that anything he did right or wrong. It just so happened when he got nominated, it was to fulfill that slot. It was just a calendar issue.
Wait,
Yeah.
so the newest kid on the block gets to be the head of everybody?
At that point in time, when he was appointed, he was the newest kid on the block, but yet he fulfilled the Chief Justice role. He still had to do all those new kids on the block thing, right? Answering the door when they're in meetings, taking care of the cafeteria, but it was just strictly by chance. Now here's the other thing I think you'll find interesting. Chief Justice Roberts is currently 63 years old. Justice Thomas is 70 years old. Ruth Bader Ginsburg is 85 years old. Stephen Breyer is 80 years old. Samuel Alito is 68. Sonia Sotomayor is 64. Justice Kagan is 58. Neil Gorsuch is 51. And Brett Kavanaugh is 53. Just based upon age, you can kind of see that the Clinton appointees are probably the most likely next to be replaced.
Yay.
Why do I bring that to your attention? This just goes to place a lot more emphasis on voting, right? We've seen, if you notice here that the previous presidents all have 2 justices with one exception. George H.W. Bush, number 41. But you also have to keep in mind, he only served 1 term, right? The other presidents on there, with the exception of Trump at this point, they all served 2 terms. They all had 8 years with which to place justices on, whereas H.W. Bush only had 4 years. Well, in 2 years, Trump has already put 2 justices on that court. And it's looking likely, maybe even a 3rd. So there's still hope for me. No. Seriously though. So that's why I bring this to your attention. One, I wanted you to understand how one becomes the Chief Justice of the Supreme Court. It's strictly luck of the draw when they get nominated. And then also looking at the ages, because it is a life appointment. The average lifespan in the United States right now, as far as I remember, is still 78, 79 years old. So, and you can already see the health issues that Ruth Bader Ginsburg is suffering from right now. So for the first time, she's actually missed oral arguments. Since she was appointed by Bill Clinton, she's actually missed oral arguments for the first time. So I don't know what her status is right now. Fox News seems to disagree with the rest of the world. But, all right. So you, as an individual, if you don't like what happens to you in the trial court, which is, I'm a judge of a trial court, but in the federal system, it's a district court, you have an absolute right to an appeal. If you think about it, this is really how the foundation of our country was started, right? We did not like giving the decision to the one, we wanted to give it to the many. And so if you don't like what happens in my court, you have an absolute right to redress with the appellate court. My appellate court is in Dallas, the 5th Court of Appeals. Same thing in the federal court. If you don't like what happens to you in federal district court, the trial court, you have an absolute right to appeal to the circuit court, right? There are 13 circuit courts around the United States, including the District of Columbia. Our circuit, like I explained to you, is down in New Orleans. But you do not have an absolute right to go to the state of Texas's Supreme Court or its colleagues, the Court of Criminal Appeals. You do not have an absolute right to go before the Supreme Court. That is discretionary. The court gets to decide whether or not they want to hear your case. You don't have an absolute right. It's called Petition for Discretionary Review, a PDR. You have an absolute right not to hear your case. So, in this October term, starting in October of 2018 that they're currently in, the United States Supreme Court has opted to hear, out of the thousands of cases people petition for, they're going to hear 54 cases this term. So out of that 54, I kind of went through 54 and I decided, there's probably 18 that you might find interesting. Like I said, if you fall asleep, I'll have to get personal. All right? So, 54 cases in basically a 10-month period. That's 9 people's workload. All right? Now, first I want to discuss the 8th Amendment. The 8th Amendment says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Okay, that's what the 8th Amendment says. So the Supreme Court this term has decided to bring up some 8th Amendment cases. Timms versus Indiana. That's the first case of the 18. Timms was a heroin user. His father passed away, and he received proceeds through an inheritance through an insurance policy that the father had. of $75,000. So he took, very wisely, took $40,000 of the $75,000 and bought himself a brand new Range Rover. And then the remaining $35,000, he decided, well, what's important to him besides the Range Rover is heroin. So he blew it all on heroin. And he would go from Ohio, where he lived, over to Indiana to buy his heroin. He got tied up in the drug trade, did some buys with undercover officers, and subsequently was arrested for this heroin. When he went to court, he was found guilty of the criminal offenses, but those crimes in the state of Indiana carried with them a maximum fine on the crime of heroin possession and heroin trafficking of $10,000. But a lot of you probably have heard of these civil forfeiture laws. They're becoming more and more brought to light in the media. And Indiana decided, you know what? You had that Range Rover. It's what you were driving when you were going back and forth with the heroin. So we're going to, under the civil forfeiture laws, take your Range Rover from you. And this happens. Even in the state of Texas does this. So don't think that this is anything unusual. All right? So the argument, though, that the attorneys made is, does this violate the excessive fines aspect under the 8th Amendment? It's not really a fine because it's civil. It's not part of the criminal. And so the argument is, look, this Range Rover is $40,000. It's 4 times more than the maximum fine you could have gotten on the criminal case. Plus it's civil. He doesn't have a right to counsel because it's civil, right? This is just very unfair. Now this case is important because a lot of states have these civil forfeiture laws. Some have followed the United States law that says these things are excessive. Some do not. Indiana is one of those. Indiana says, look, we don't recognize that United States law, the federal law. We're going to follow our state law. So the question is, does the 14th Amendment, remember the Civil War, does the 14th Amendment therefore require now the states to follow the federal law? So the reason I brought this was interesting because Texas has these laws. Be aware of them. All right? This is not unusual. It happens in the state of Texas, both at the state as well as the federal level. But what you should be interested in, what I found was really interesting, is anybody heard of Tom Fitton?
Oh, yeah.
Okay, good. Awesome. Judicial Watch. Judicial Watch, Tom Fitton, and his group actually filed an amicus brief. Now, what an amicus brief is like, look, Supreme Court, I'm not one of the 2 litigants that are before you on this case, but I have reason for a stake in the outcome. Can I file a brief on behalf of one of the other parties? Tom Fitton has, in fact, been granted permission by the Supreme Court to file an amicus brief in support of doing away with civil forfeiture laws. So I thought you would find that interesting. There are 2 groups that I really think deserve your support with regards to these matters. One is Judicial Watch, and the other one is First Liberty. And we'll get to First Liberty in a moment. But if you were inclined at all to decide to donate money to an organization that has nationwide influence, I would recommend researching in those two organizations to you. Now, the 8th Amendment, cruel and unusual punishment. These death penalty cases fall under the 8th Amendment. So this particular case is Madison versus Alabama. Interesting facts. Madison has been on death row for 30 years. 30 years he's been on death row. Madison then suffers, while he's incarcerated, he's got I believe it's a March execution date set already. While he was incarcerated a couple of years ago, he started having strokes, some vascular strokes, that caused him, therefore, to suffer dementia. So now he doesn't even remember the incident to which he was placed on death row for. So now, because he's been on death row for 30 years, at the 28th year mark, he's like, well, I don't remember what happened 28 years ago. So now the issue is mental health. The Supreme Court's going to look at this and say, can the state execute the defendant even if they now have no memory of the criminal act? Now, I want you to understand something. If at the time the act occurs, if the defendant does not know, mentally, does not know what they're doing is right or wrong, we have a defense to that case. It's called the insanity defense. Right? If at the time of the incident they did not know what they were doing was right or wrong, then it's an affirmative defense. It means I committed this act, but I didn't know what I was doing. Okay? This is a little bit different. It's like after the fact, now I have no memory of it. Now, the reason also I wanted to bring this to your attention is because we have, as a group, you're very involved and you understand judicial activism. And last time I was here speaking about the Obergefell case, right, the homosexual case, I explained to you about the legal writing, the holdings that were there in place, and the verbiage that's being used. And the verbiage will kind of give you an idea of where they're headed. So whether, here's the issue, whether evolving standards of decency in the Eighth Amendment. I love Scalia, God rest his soul. And he said it best. He said the Constitution says what it says, and it doesn't say what it doesn't say. Evolving standards. That sounds like judicial activism to me. So just based upon that verbiage and that verbiage alone, right now, it seems as though the Supreme Court might be leaning towards the fact that this might in fact be a violation of the Eighth Amendment. Evolving standards of decency. All right? Another death penalty case, Buckley versus, I think it's Preseith, I'm not sure. Buckley was placed under death row in Missouri. Missouri uses
the judge that
injection.
Who fought for the right to hear the case, because all the judges see the cases and then they put their little wish lists in to see what they.
And he actually drew the long straw.
So who was the judge that wanted to bring that up for the Supreme Court?
No, it was the parties. Actually, the inmate on death row has a liberal organization representing him. It wasn't the judge.
But what of the Supreme judges?
Oh, I know. They sit in committee and they decide whether or not they want to hear cases as a group.
Okay.
So it's not just one.
But,
And I don't know which ones actually decided.
You don't ever know which judge actually fought.
I won't go so far as to say you'll never know, but I don't know.
Yeah.
All right. Now, but I will tell you, this case is interesting. Okay, so Missouri uses lethal injection. So does the state of Texas. All right. This is why I thought this was interesting. The argument is that Buckley suffers from some medical conditions, and if the lethal injection were to be used, it might cause him, due to his medical condition, to sit there and choke for about 4 minutes. And so they're arguing that this is cruel and unusual punishment. All right. So remember, the other one was a mental issue that they're going to address. This one is a medical issue that they're going to address. And here's the questions they're looking at answer: whether a court evaluating a challenge to the state's method of execution based on an image, rare and severe condition. Okay, that's not really what I thought was interesting. This is where I really thought was interesting. Number 2, whether evidence comparing a state's method of execution with an alternative proposed by the inmate. The inmate getting to choose. I choose death by old age. That's what I want, Judge. I think that would be fair. I'll still be put to death. I just prefer that it be done by old age. I mean, I kind of make fun of these things, but look at that. Proposed in the alternative by the inmate. It seems kind of ridiculous to me.
But there's been cases where it's been a while, but they actually wanted to be shot by firing squad.
Yeah, Utah, I think did that for a while. Yeah, that's correct. I shouldn't make light of it, but I mean, just look at that question. Proposed by the inmate.
I see the humor in it, but there have been states that actually would let you pick.
This is kind of collaterally being attacked here in the state of Texas, right now. A few years ago, some groups were filing to find out who was actually providing the phenobarbital that we used for the lethal injection. And the district court that heard the trial court, the state, by the way, these are state courts, not federal at this time in the state of Texas. So my colleagues heard this case down in Houston. They said, yes, you have to divulge that information. You have to divulge who is actually providing you the phenobarbital. The appellate court in Houston agreed with the trial court, said, yes, they have to divulge it. At that time in time, though, our Attorney General for the state of Texas was Greg Abbott. And Greg Abbott wrote an opinion on behalf of the Attorney General's office saying, yeah, you do. You have to disclose it. A couple years passed, and so the legislatures took action here in the state of Texas, and they passed a statute saying, no, you don't have to disclose it. But the problem is this case was filed in the state of Texas before that statute was enacted. Mm-hmm. Now, the governor, Greg Abbott, is going back and saying, well, maybe we shouldn't do that, and he helped pass the statute. The interesting thing, though, is initially the Supreme Court of the state of Texas denied to hear the appeal. Remember, they have discretion. But they have gone back now and decided, you know what, we are going to hear this because the state of Texas filed a response that said, if we have to divulge this information, it could be irreparable harm to the providing company and they won't provide it to us anymore, and we won't have a provider. So the Supreme Court of the state of Texas is now going to hear this appeal. I tell you that because this isn't just a Missouri issue. And granted, if it's the United States Supreme Court, it will impact us. But we are still fighting this similar battle here in the state of Texas right now. All right? Foreign immunity. JAM versus International Finance Court. I know nothing about this case. All right? But why did I put it on here? Because I learned something. Tertiary standpoint, we learn about immunity issues in law school. Immunity issues affect my court. We still have immunity issues. I still have people coming before me as litigants saying, Judge, I'm immune from lawsuit. So I do understand it from that standpoint. What I did not understand was the IOA and the FISA. Now, what you need to know about immunity means that if you have immunity, you cannot be sued for any reason. If you do get sued, you need to go to the court and say, court, you have no jurisdiction over me because I have immunity. You can't do anything to me. Sometimes it's provided by treaty by the United States. For example, the International Monetary Fund enjoys absolute immunity. Can't sue the International Monetary Fund. Same thing with the United Nations. Right? They can go speed around New York City all they want, trash that place, tear it up. They cannot be sued. All right? So that's done by a treaty. The United States has agreed to this. Other than that, though, there was a 1945 law and then a subsequent 1976 law. And there was a conflict that arose at the trial level as well as the appellate level. And at both of those levels, they said, you know, that 1976 case that law doesn't apply in this particular case. The 1945 case does. The 1945 law, though, was very interesting. And what it says is it's strictly up to the discretion of the executive branch whether they don't want to grant immunity, and they get to decide that on a case-by-case basis. Maybe this week on this issue you get immunity, but next week on a different issue you don't. Same organization. And I really thought that was interesting. Case by case, strictly decided by the executive branch. Now, you're a very well-informed group here. I'm sure you've been following the news, and there was a recent filing in the federal district court where they decided that they granted the attorney's desire to have it completely sealed, not only the filing, but the hearing itself, which is generally contrary to how we operate our courts. We have open courts. We didn't like the king taking us back in the woods and doing whatever he wanted to, right? So it was really unusual. It made the media like, hey, why is not only was the federal courtroom shut down in New York, the entire floor was shut off to anybody, public or even the media. And then the appellate court heard this and like, yeah, you know, and I don't know any of the facts, okay, because it was sealed. The appellate court heard this and said, when they were deciding to hear the appeal, they're like, yeah, that's right. They shut down the appellate court. Not only sealed the filings, which isn't that unusual, they sealed even who the lawyers are. They sealed who the litigants are. It's completely shut off. And then the Supreme Court now is trying to decide whether or not to hear this case in a sealed way. They haven't decided, so it's not one of my 18 years.
So what did this Buddha Ishmael?
I don't know any of the facts of the case, but this is where I was going with it. It would not be an interesting issue if, say, hypothetically, because I don't know any of the facts, a foreign entity being maybe a bank. They got a subpoena from Mueller. This is the whole Mueller subpoena issue you probably heard. And then the federal judge says, yes, you do have to tender that information over. And they said, well, we have immunity. And it says, no, you don't have immunity. It doesn't apply. And every day you don't turn over those documents that were subpoenaed by Mueller, you're now fined $50,000 per day for not turning it over. But wouldn't it be interesting if the person that they're investigating had the ability to grant that individual immunity? If that is in fact true, and they're investigating Trump, he's the executive branch, he says, no, you don't turn over my bank records because you're a foreign entity, and I'm granting you immunity. Wouldn't that be an interesting constitutional conundrum? And I don't know this to be factual, but when I saw this, I learned a little bit about immunity, and I was trying to apply it to what's going on today, and I thought, wow, that's pretty interesting. So I thought maybe you guys would find that interesting too, or not. But think about that. If the executive branch gets to decide whether or not they grant immunity, and then they're the ones being investigated, wouldn't that present an interesting question?
There was a UN member back in the 70s that had raped a maid in a hotel. And I remember this as a kid because I was thoroughly outraged, and he had immunity. And the way they handled it was they kicked him out of the country, and he wasn't allowed. It was on a no come into the country list.
They can do that, but he didn't get.
But he did not get arrested. He did not get prosecuted or anything.
So that prior slide was about foreign entities having absolute immunity in the United States courts. But what happens, what about one state versus another? I mean, if a foreign entity has immunity, wouldn't it make sense then that one state would have immunity from another state? If we're going to give those privileges to a foreign sovereignty, why not at least give them to the state, right? Franchise tax board in California versus Hyatt. This isn't Hyatt like the hotels. This is an individual, a genius. Hyatt owns a lot of patents. And rather than selling those rights, that intellectual property, he decided wisely to lease it out. So in the early 90s, he made hundreds of millions of dollars from his patents in California. But just like everybody else moving here to Texas, he didn't like, even in the early 90s, having to pay estate tax in California, which has only gone up since then. I really like this Hyatt guy for a multitude of reasons. So, in 1992, he was going to get a large tax bill. So he decided, you know what, I'm going to up and move from California and I'm going to go to Utah, where it's friendlier, a lot friendlier towards the tax base. And so he wrote, in response to his state income tax to California, he said, well, you know what, I don't have to pay taxes because I moved. I moved as of October 1st, 1991, and California then did an audit. Do you think California really wants to forego that tax money? They said, no. We did an audit, and we found that you actually moved in April of 1992. So not only do you owe us back taxes for 1991, we want taxes prorated for 1992. Well, the 1991 tax bill was a little over $1 million, plus they're seeking interest, plus they're seeking penalties. But 1992, for that 4 months, it was already now up to $6 million, right? So, they're still fighting, by the way. 1991. This guy still has managed not to pay that tax to this day because he's still fighting. But what he decided to do was, in Nevada court, he decided to sue the Franchise Tax Board for a myriad of torts, civil wrongs. And California said, look, you can't sue us. We're immune. We're California. You're in Nevada. And Nevada courts looked at it and said, no, actually he can sue you, and you better answer this lawsuit. And so the Ninth Circuit took up the case, and now the Supreme Court's going to take up the case because they didn't like what, or they probably didn't like what the Ninth Circuit did. But I really found that was interesting because one, it had to do with taxes, which we all don't like. But I really appreciate Hyatt because he's been fighting California taxes now for going on almost, 30 years? And he's still fighting. And then he decided, you know what, you're going to take me to court? I'm going to take you to court.
Yeah, but he can afford it, and if California loses, it's the taxpayers that's going to pay it. It's not going to be any governor or anybody like that. It's going to come out of the people's pocket.
Well,
So that
I just
that
like his
blows.
fight. It just kind of is congruent with our country, right? It's like, talk about Tea Party, getting taxed on your tea. He's going to go fight him. I just really appreciate the guy. But I just thought that was an interesting case because it deals with sovereignty. Sovereignty. We're going to give a foreign entity the ability to not go to our court, but we're not going to give the same to a state. Right? They're here. They're part of us. They're part of our civilization and our society. And we're not going to give them the benefit that we give to a foreign entity? Now, dual sovereignty. I just threw this side in here because it had to do with sovereignty, but really to educate you. Because this is a question that has been asked on every bar exam in the state of Texas for the last umpteen years. Because it throws a lot of people off. Most people have heard of res judicata, double jeopardy. And what that means is if you get tried for a crime, you cannot be tried again for that exact same crime. Right? Double jeopardy, res judicata. So Gamble versus the United States, the Supreme Court is actually going to take up whether or not that's lawful. Because what you have to understand is that if you commit a crime, the exact same crime, you can be charged with that crime in the state of Texas as well as the United States of America in federal court. You have the potential of being found guilty in state court and not guilty in federal court for the exact same offense, or the inverse. Now, when I was a state prosecutor, I had some cases that were taken by the United States attorney, and invariably I would just dismiss because, in my case, because they're going to go federal with it, and why waste your taxpayer dollars, right? Let the federal system pay for them. But I didn't have to. I could have prosecuted that person for the exact same offense, the exact same transaction that they did in the federal system. That is not currently double jeopardy because the state of Texas is a separate sovereignty than the United States of America. Does that make sense? Separate sovereignty. So for me, it's really interesting that they decided to take this case up. I'm really interested to see what they're going to do. Are they going to keep that the law? You can be charged the same criminal offense in state court as well as federal court? And if not, then who wins? I would think the 10th Amendment might come into play, but they never decide cases on the 10th Amendment. So I threw this into also because of sovereignty issues, so you understand that. The state of Texas is separate sovereign from the United States. And right now, the state of the law is that you can be charged with a crime in state court as well as federal court, and it's not double jeopardy. A lot of people don't know that. That's why it's always on the bar. Anybody here interested in sanctuary cities? All right. All right. Nelson versus Priapt. The question is whether a criminal alien becomes exempt from mandatory detention if the alien is released from criminal custody and ICE does not take them immediately into custody. Wow, Ninth Circuit. What do you think they have?
Yeah.
They said, look, if you release them out of the jail and you're not out there to pick them up right away, they are no longer subjected to you detaining them
Is this
under
the
federal law.
Case where the judge let the guy out the back door.
I don't know the facts of this particular case, but they're all the same. This is the sanctuary city, so you really want to follow this particular case.
Well, in the case of California, sanctuary state.
Sanctuary state, but again, we see the Ninth Circuit. I mean, that's just, that doesn't make your blood boil. I don't know what should. First Amendment, we talked about the 8th. First Amendment. First Amendment says Congress shall make no law respecting any establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government to address its redress of grievances. So they do have some First Amendment cases on their docket. They're going to hear. Neves versus Bartlett. The current issue is probable cause versus retaliatory. So you have to have a little bit of background information. There are different levels of burden of proof that we have in the criminal justice system. The lowest one is a hunch. If an officer has a hunch, hey, you're involved in crime, it doesn't matter if their hunch is right, wrong, indifferent, they have absolutely no legal right to make contact with you. All right? Just a step up from there, though, is reasonable suspicion. Reasonable suspicion is, do they have articulatable facts that would cause one to reasonably believe that that person was involved and that crime was afoot? So they can go and they can investigate. They can't arrest you on that. They can at least now initiate contact and continue their investigation, right? So down here we have a hunch, can't do anything. Just above that, now I've explained to you, is reasonable suspicion. Above reasonable suspicion from a burden of proof level is probable cause. Did this person probably commit the offense? That is the minimum level that they're allowed to now make an arrest on. So they can arrest you for that. You may not be found guilty of the offense, but you're going to be arrested and charged with the crime. Then you get all the way up to beyond a reasonable doubt. There are other levels in the criminal justice system that don't deal with crimes. You've probably heard of preponderance of the evidence. That's a civil, it's not a criminal. You've probably heard of clear and convincing evidence. That's civil, not criminal. But all the way up here, the highest burden of proof we have in the entire justice system is beyond a reasonable doubt. And that's what was required by either a judge or jury to convict somebody, to find somebody guilty of the offense. Right? It's not 100% certainty, some less than 100% certainty, but it's pretty darn close. And it's been that way since the inception of our country because our founding fathers wanted to make sure we got it pretty darn right, before we started labeling people as criminals and we took away their freedoms and their liberties, which is fine because that's exactly what we do to people who commit criminal offenses, but that's also why it's the highest legal burden in the entire justice system. So mere probable cause to arrest, but you can't be found guilty of that offense unless it's proven beyond a reasonable doubt. Does that make sense? So, probable cause versus a retaliatory arrest. Now, the law was probable cause did defeat a retaliatory prosecution. You get arrested, the prosecutors accept the case, they prosecute you, so there was probable cause to arrest you. They take it to trial, but the juror said, there's probable cause to arrest him, but there was not enough to convict him. There was not beyond a reasonable. There was probable cause, but there was not enough evidence for us to find beyond a reasonable doubt to find him or her guilty of the offense. The Supreme Court has previously held that, that prosecution, the fact that the district attorney's office took that case, or the United States Attorney's Office took that case, well, that barred you from filing any sort of retaliatory claim. Now they're sitting there saying, well, what about mere probable cause? It never got taken up by the district attorney's office. but there was probable cause to arrest. Neves versus Bartlett is a really interesting fact pattern. There's a big party going on in Alaska during the summer. Keep in mind, they have white nights there during the summer. It doesn't get dark. These people party all night long because it's just daytime to them. The police show up because this party got out of hand, a little rowdy, and then one of the officers looks over and sees the person who they believe to be underage drinking. So as they make contact with that person that they thought was underage drinking, another person walks up and gets in their face and they arrest him for obstruction of justice. Now he's suing the police. That's what this is about. The person arrested at this party is now turning around and suing the police. Right? Maryland National Capital Park and Planning Commission versus the American Humanist Association. Does everybody know who the American Humanist Association is? 'Cause I didn't. You did? All right. I didn't know who it was. I had to look it up. I briefly mentioned about Kelly Shackelford's group, First Liberty. There's 2 cases dealing with this removal of a cross from a World War I memorial. This slide and then my next slide. So case number 9 and case number 10. The Supreme Court has agreed to hear both of these cases, but they're going to hear them together. This one is whether or not the Establishment Clause was violated. What I really found interesting was that the Fourth Circuit, the appellate court, federal appellate court that initially heard this case, granted summary judgment. A summary judgment, a judge is to grant it if and only if there is absolutely no factual dispute and it's merely a matter of law. No factual dispute at all. We agree these are the facts, we just disagree about how the law applies to them. So they don't even hear argument. It's just all by doctrine. Usually it's done by doctrine. So they just took it as a summary judgment issue. So that kind of threw me back a little bit that they didn't care so much about this case to even hear arguments. So the grieving party wrote back and said, look, the 3 of you that decided this in summary judgment, we want everybody to hear it. We want you to hear it, and we want all of the justices here. We call that en banc. That means every single, so normally when a case gets appealed, only a subset of the justices hear it. Usually 3. In this particular case, they asked that all of the justices hear it. And give us our fair shot. And an 8-6 vote, so in this particular court there are 14 different appellate justices. 8 of them said, no, we're not going to hear from you. Now, so the American Humanist Association, this is right off their website. It stood as a voice for humanism, I don't know what that is, humanism in the United States for over 70 years. But this was enlightening. We strive to bring about a progressive society where being good without a God.
They're their own gods.
The
Being
best
good.
description I ever heard of them
Okay.
is a group of perpetually offended atheists.
They don't like God.
Exactly right.
Well, everybody in our country has a right to redress, right? But I just thought this was interesting. Because if you look at the amendment, there it is. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise. There it is. Seems to me like if that's my mission statement, my organization, it seems like they're trying to prohibit the free exercise. There it is. So anyways, here's the other one. American Legion versus American Humanist Association, again. Same cross. This is a little bit different issue. Whether it's unconstitutional merely because it's shaped like a cross, whether or not just even the passive display is unconstitutional. Passive display, unconstitutional. But now they're going to allow hijabs on the congressional floor. Isn't that a passive display? And the other thing is whether or not public funds can be used just for the routine upkeep. Well, that's an interesting question. Kelly Shackelford is involved in this one. First Liberty and his group, and also, like he does, went and got some really top-notch lawyers to assist him in this. So this is another one you want to keep an eye out for. Lamone versus Benesek and Rucho versus Common Cause. Anybody familiar with these 2 cases? All right. First Amendment right not to have the value of their vote diminished because of political views. We call this gerrymandering, right? Probably familiar with that. Interestingly enough, Lamone versus Benesek, Republican voters complained about Maryland. Rucho versus Common Cause, the Democrats complained about North Carolina. So apparently nobody from a political organization likes gerrymandering. So it seems if it's equally offensive, it must be fair. but
Has there been a bunch of gerrymandering cases?
there have been. I'm surprised that they're taking more up. You would have thought that this was a resolved issue. Usually they don't like to get involved in gerrymandering cases, so it'd be interesting to see why these two were particularly taken up.
Because I thought it was pretty well settled.
Well, I thought so too. I'm going to read this to you because this was on the Lamone versus Benesick filing. I really found that this was interesting when the lawyer stated this to the court. I said, if this court, talk about slippery slope, okay, this is the quintessential slippery slope argument. If this court does not condemn gerrymandering, then it will give a green light across the country to engage in gerrymandering in 2020 like never before. It will make 2010 look like child's play. I thought that was pretty interesting. A typical slippery slope. If you don't do something about it now, it's going to get worse. It's going to be mayhem.
Sounds like he's entertaining.
But I agree. I thought that this was pretty much well settled. They weren't touching these things, but they've agreed to hear both of these cases. So it will be interesting to see what they decide. Big pharma. A lot of media attention has been given to pharmaceutical companies, opioid addiction. Usually we look to the federal government, in theory, to protect us, to make sure that our food is safe to eat, our roads are safe for us to be in, our schools are safe for our children. We usually look to government in a positive way to protect us, right? This is an interesting case. It's Merck Sharp and Drug versus Albrecht. Fosamax. Is anybody on Fosamax? You want to get into it? I did not know what Fosamax was. Apparently it's an osteoporosis drug. I had to look it up. So Merck Sharp and Dohme creates this drug, and they do all these testing as they normally do. And in the process of doing this testing, they found out that it could potentially have some pretty nasty side effects. So when they were getting their blessing by the FDA to put this into the market, the stream of commerce, they notified the FDA that we have all these nasty side effects. And then you know what the FDA said? No, you don't have to notify those people of that. Oh, no. So what happens is then, so people suffered some pretty nasty side effects, and Merck Sharp and Dohme got sued at the state level. And they said, you didn't notice us, you didn't notify us that these were to be an informed user of this drug, that they had these pretty nasty side effects. And they said, well, you know what, we did. We notified the FDA, and the FDA told us not to put these in. So the question is now whether or not the state law for failure to notify would be preempted by the federal law. But I just thought this was an interesting case, because normally we look to the federal government to protect us, to make sure our food is safe, right? Provide us the military to make sure our borders are safe. And in this particular case, the FDA said, no, don't inform of those. New York. I think New York has Me Tooism. And by that I mean, they look to California and say, hey, wait, what about us?
Yeah.
What about us, California? Wait, we're over here. Republic of Sudan versus Harrison. I don't know any of the facts of this case. I put it on here because the Second Circuit, which is in New York, Ninth Circuit's in California, the Second Circuit in New York, they looked at the same fact pattern or similar fact pattern in some of the other appellate courts, and they said, you know what, you other appellate courts, District of Columbia, the Fifth, the Seventh Circuits, and even the United States filing amicus brief, even the United States saying, no, the Second Circuit says, you know what, Columbia, Fifth, Seventh, United States, you're wrong. So I'm going to decide it the other way. I thought that was interesting. Again, another one, whether or not they were right versus the Sixth and the District of Columbia. But then there's California. Thank God for California. City of Escondido. This is a really interesting case. The United States, we talked about immunity. So you understand in certain circumstances, people, certain types of individuals enjoy immunity. There's a good reason for it. I, as a judge, enjoy immunity if what I'm doing has directly to do with what my job is. Right? If you don't like what happens in my court, you don't get to sue me personally. You can take it down to the appellate court, but you don't get to sue me personally. If I do something extra outside of my judicial capacity, that's a different situation. I can still be sued individually. So the United States Code allows you to sue certain types of individuals who normally would have immunity if you meet certain criteria. It's 42 U.S.C. 1983. You might have heard of it as a 1983 action. These are civil rights actions. If I get beat up by the police and I can prove certain elements, I can get past their immunity for their job. All right. So in this particular case, There are multiple prongs, multiple things that have to be proven though, however, before you're entitled to sue somebody who normally does have immunity. Otherwise, they have immunity and you can't sue them, all right? So, the question is whether the Ninth Circuit, oh, thank God for California, failed to conduct the analysis required by the United States Supreme Court. So Escondido police officer, they show up, they get a call out to a domestic violence dispute, they show up. Evans was there, he's coming out of the house where they have reason to believe there was domestic violence occurring. Officers make contact with him, they tell him to stop. What does he do? Like any rational person? He ignores them, runs back into the house, slams the door behind him. So now the police give chase.
Sure.
Because now they're concerned about the female that was inside. So Evans sits there and decides to sue the police officers, claiming that even though they violated his right to privacy. So here's a little brief excerpt of it. When he filed a lawsuit, there was absolutely zero authorities for the proposition that this nature of force was excessive and therefore unconstitutional. The district court, that's the trial court, like my court, the district court said, you know what, they have immunity, you didn't meet your burden, so you cannot sue the police. The appellate court said, look, you didn't meet the second prong of the qualified immunity, so you don't have a right to sue these police, so you cannot sue them, they're immune. The Ninth Circuit, God love their wisdom. They reversed the appellate court. They cited a single case that happened well after this case actually happened. But in it they said, simply without elaboration, the right to be free of excessive force was clearly established at the time of the events in question. Really? Appellate courts aren't supposed to be fact finders. They're there strictly for legal review. The appellate courts will defer to me, the trial judge.
How do they get away with it then? If it's not
Well,
supposed to.
They didn't.
Then
We're
why
not yet getting away with it, thank God for the Supreme Court. But look at this. This is what really drove me crazy. You remember how our country was founded? We want to take the decision making out of the one, the king, and give it to the many. Now, we're not a true democracy. We are a republic, right? But
We're not even-
we didn't like what the king was doing to us and just doing whatever they wanted to. But look at this. The panel below explicitly barred the officers from seeking any review by the circuit. We're going to overturn it, and you can't come back and ask us why or ask us to reconsider it.
Wow.
Ouch!
That's right.
Now, thank God the Supreme Court's looking at that. Actually, in this case, I will tell you, remember I told you normally the Supreme Court will have oral arguments. First time ever Ruth Bader Ginsburg has missed some of those. In this particular case, the Supreme Court, when reviewing whether or not they wanted to look at cases or not, out of the thousands, they chose 52 or 54, whatever I told you it was. In this one, they said, I don't even need oral arguments. They just simply reversed the Ninth Circuit and sent it back. They didn't even hear it. Talk about a slap in the face. They did exactly what this court told them. Don't come back. The door is now closed. Do not ask us to reconsider this. It's done. So I thought that was kind of poetic. I didn't read the holding. I don't know if it was per curiam or not, but I just thought that was interesting.
Interesting. That's funny.
So they did
Yeah.
basically to the Ninth Circuit, what the Ninth Circuit was trying to do to the Escondido police officers.
The Ninth Circus.
For doing their job. Oh my gosh. Who wants to be a police officer in this day and age if you're going to get sued for doing your job? And then the federal court says it, don't come back. All right. California versus everybody else. Nutraceutical Court, Lambert. Whether the Ninth Circuit was correct when it held an equitable exception. So you have to understand equitable exceptions. An equitable remedy is one that allows me as a judge to sit there and say, you know what? You've been wronged, and so I get to decide how to remedy you. All right. Criminal cases are courts of law. I don't get to decide that. You either violated the law or you didn't, as long as it was proven beyond a reasonable doubt. Equitable remedies are like, yeah, you kind of did, you kind of didn't. You built the fence, 80% of it, but you didn't technically complete it all. So I'm going to give you 80% of the revenue you would have normally received, whatever it is. That's an equitable remedy, okay? So it's kind of wishy-washy. It's not judicial activism because that's what we do as judges, all right? I'm not changing the law. I'm not changing the interpretation of the law. I'm just trying to do an appropriate redress to the parties that have a grievance before me. You two can't get along, so it's like having two kids. You two can't get along, so I'm going to split that banana, whatever it might be. That's an equitable remedy, okay? So Now, whether equitable remedies apply to mandatory claim, it's mandatory. It's not discretion, it's mandatory. In conflict with now the second, the third, the fourth, the fifth, the seventh, the 10th, the 11th. Oh my God. Yes, the Ninth Circuit saying, oh, you got it wrong. You guys got it wrong. We're right. We're right. You know it's mandatory. Mandatory, what does that really mean? We're right. You're wrong. So now the Supreme Court has to fix this one. Emulix versus Varja Bendian, I think is how you pronounce it. Whether or not the Ninth Circuit was wiser than everybody else, or 5 other circuits got it wrong.
Have they ever done anything that wasn't overturned?
I don't know. I don't know.
They must
Um,
have a Supreme Court case.
That's why we need another revolution.
Currently, the 54 cases set to be heard.
Wow.
All of those cases came from one circuit.
Yeah.
If you add in those 2 from New York that are the Me Too-isms, the, hey, don't forget about us over here being wiser than all the other circuits, that's 9. 9 out of the 54. Fully 1/6 of the cases on just 2 circuit courts. Takes up 1/6 of the entire Supreme Court docket for a year just to address what's happened in those 2 circuits. Because they thought that they were wiser than all of the other circuits. If they had just followed precedents from the other circuits, what they're supposed to do,
Yeah.
these wouldn't have been questions. And do you think maybe the Supreme Court could have gotten to more pressing issues rather than just having to fix these?
They're
They
tying
just
up
have
the
an
system.
agenda, that's their problem, they're all,
No, say it isn't true. That they have an agenda? You think
You
politics
know,
plays
like
into
the
it?
police, you've seen attacks on the police in the last, 5 years. Neutering the police is right out their alley now, because that's part and parcel with their constituents.
All right.
Yeah.
What they didn't hear. I'm not saying they couldn't have, if they didn't have to deal with those other cases, but what they chose not to hear. They did choose not to hear Trump's ban on transgender in the military, so the lower court ruling holds, and so they can go forward with banning transgenders from the military. They decided not to hear the DACA, the Dreamers. They decided not to hear that. The lower court's ruling says that Trump now has to continue to allow the DACA recipients to stay. That doesn't mean they won't do it in the future. I'm just saying right now, because they're having to do other things. They're not hearing Indiana's law banning discriminatory abortions based upon race, based upon gender. Now, this is interesting. Kelly Shackelford had another one before the Supreme Court. He petitioned the court to hear it, and they decided not to, and that's the Coach Joseph Kennedy fine. You're probably familiar with this, praying on the field after the games. Now, don't be discouraged. I'm on a distribution list, and Kelly Shackelford received notice from the Supreme Court. It's actually encouraging, because while they decided not to hear it, they basically sent it back down with a roadmap for Kelly to win at the district court level. So it's just because they decided not to hear it at this point in time, it's not over and the fight continues, okay? So I just want you to make sure you understand, just because they decided not to hear it doesn't mean it's over in this particular situation. And that just happened like yesterday or the day before, so. Handguns, Second Amendment. Supreme Court hasn't taken up a Second Amendment case in over a decade, right around a decade. And so there's a case out of New York City. There's a lawful gun owner. New York has a law. So let me digress a second. The previous case that they took up in the Heller decision says you have an absolute constitutional right to have a handgun in your home for personal protection. All right, that was the Heller case that they decided about 10 years ago. They haven't touched another case since then. Well, the city of New York says, okay, fine, we're going to have one in your house, but guess what? You can't transport it anymore. You can't transport it across city lines. So as a lawful gun owner says, hey, look, I go shoot at my range in upstate New York. It's outside of the city that I live in. Sometimes I even go all the way over to New Jersey and shoot lawfully. Sometimes I carry it to my second house at another location. But that's crossing city limits in violation of New York's law banning that. So the United States, the Supreme Court did just decide that they're going to take that up next term. So they're full for this term, but they're going to address that next October. All right?
Weren't there cases already settled, I forget, Baltimore maybe? Where
Baltimore?
Well, not the.
Whoa, when do you get
No.
Baltimore involved?
No,
They don't even
there's-
allow handguns in their schools anymore
yeah.
by the police officers.
In Washington DC, they were banning transport of guns.
Well,
and-
DC, that's the Heller case came out of DC, and that was, they were banning even in your home,
Yeah.
You're a peace officer, you can't even have, as a police
And
officer.
that was decided, that
That was decided.
your car is your home and you
But-
can transport it.
Well, but now they're taking up this case, all right? Which is good, that's good for us. If you're pro Second Amendment, frankly, if you're pro Constitution, it's good for us, right? Now, well, that's the conclusion of my presentation about the Supreme Court and the 18 cases I thought were more interesting, and then also understanding about the Fifth Circuit Court decision with regards to Planned Parenthood funding in Texas, with regards to the other cases that they decided not to hear. That's 9 justices. That is a full load, 54 cases? People good at math don't go to law school. 54 cases is a full load for 9 justices because they work, 10 months out of the year. Just so you know, here in Collin County, myself, I have 6 colleagues. There are 7 of us, so that's 2 fewer than the Supreme Court. There are 7 of us. Last calendar year, in 2018, we had 16,102 cases filed, split amongst the 7 of us. Out of that, we managed to dispose of 9,954 criminal cases, 4,906 civil cases
Wow.
between the 7 of us. And we don't have teams of lawyers working for us. We have 3, me, myself, and I. So that thing, I would hope that you would then put things into perspective. I'm not saying that the cases we settle are as heady as these, but I guarantee the litigants coming into our courtroom, it's just as important.
True.
We're down here working every day. 16,000 cases filed, split amongst 7 judges versus 54 amongst 9 with a team of lawyers. So I just thought you guys would find that interesting. Maybe not. 7 basic, graduated 4th out of my class in 1988. I was on the Sol Ross Scholarship in the Corps of Cadets for my performance. God's telling me something here. I don't want to do this all over, so I transferred to Austin College, graduated cum laude, did some consulting work, and then eventually went to law school. So God has a plan. I'm living proof of it. So Mustang was definitely on my agenda, but I just decided, and it was not an easy decision. Since 16, this was my career path. But I just decided to stop following what I wanted to do and start following what God wanted me to do. There you go. And so here I am. Anyway, thank you for having me. Again, this organization is near and dear to my heart. Thank you.
Thank you. We have a small gift for you. It's a 2-volume set on Benjamin
Small,
Franklin.
2 volumes small. You know, lawyers are the ones that call 300 pages brief, right? So,
Thank you so much.
thank you very much.
And what's the reason that we gave them books for Benjamin Franklin?
Well, Lynn is a direct descendant of Benjamin Franklin. So we're excited to have him here. Thank you so much.
Thank
Lynn.
you.